So welcome everybody to our tax event on Partnerships International Taxation. We have with us Dr. Michael McGowan, who is a visiting professor at King's College, London. Michael has had a very distinguished career as a solicitor, being a partner at all the major law firms, US and UK ones. But thankfully for us, he's always had an academic vein. So that has brought him into our tax family. And he recently completed his PhD. As I say, he's a visiting professor at King's, and he also taught at Oxford, University of Warwick, University of Amsterdam, and he's a visiting professor. So he's done some lectures for us as well. So without further ado, I would leave Michael to talk about this topic.
Thanks, Christiana. So kind. Thank you very much for making the effort to show up, particularly those of my students who get a second dose later this evening. But this is a completely unrelated topic from what I'm going to be talking to them about this evening. So it may come as a pleasant surprise to them to know that I'm interested in other things besides what they have inflicted upon them. We have 40 minutes, I believe. So what I'm going to do is focus very much on the first part of the PowerPoint. PowerPoint breaks down, as you will see, into a chunk which is very much focused on how does one actually draw a distinction, meaningful distinction between a partnership and a corporation. That's the bit I'm going to focus on. The last third of it is a bit of a digression. It consists of two parts. The first part is a focus on what is now Article 1.2 of the OECD model, which is the hybrid entity provision, which purports to give a certain amount of treaty relief in situations where contracting states differ, in particular, over the characterization of an entity. Everyone thinks about BEPS Action 2 as all about combating hybrid mismatches, which is largely true, but there is an all-important bit of it, which has now found its way into the OECD model, which is, to a degree, a liberalizing provision. Now, that's worth a seminar all on its own, so I'm not even going to attempt that. There are a few slides there which discuss it, and then last but not least, at the end, is a sort of further digression into a sort of interesting but somewhat esoteric area, which is that France has very unusual, I almost said peculiar, but I take that back, views on the characterization of partnerships, and in particular, the nature of partnership taxation. It departs from the international consensus that a partnership is in some sense transparent. It has its own unique way of looking at the world, and that has permeated very heavily the way France has negotiated double taxation treaties. Not just the UK treaty, which was negotiated about 12 years ago, but also its treaty with Japan, its treaty with the US. So I've taken the UK treaty simply as, the example I know best, but as a good illustration of the rather unusual way that France goes about dealing with these things. But enough of that. Let's focus in the time we've got on the first part of this PowerPoint, which is really trying to draw some meaningful distinctions between what partnerships are and what companies are. It goes without saying that the tax treatment of partnerships is an extremely complex area. Certainly in this country, it's not very heavily reflected in legislation. There's an enormous body of learning, which McFarlane's have recently distilled into a 685-page book, which well worth a read. It's a practitioner's book, but it's still well worth a read. And it covers all the cases, the practices, the laws, the rather complex way in which the UK has gone about taxing partnerships. And what this presentation is designed to focus on is what a partnership means. And then obviously the bit about treaties I'm going to dispense with. I've already referred to BEPS Action 2, so I won't spend any more time on this. And I've already referred to Article 1.2 of the OECD model as it now is. But let's come back to the beginning. In the United Kingdom, at least, the definition of a partnership is set out in one of the oldest operative statutes on the statute book, an act that was passed in the high Victorian era after 11 years of rumination in Parliament, the Partnership Act of 1890. And as all English lawyers know, and indeed Scottish lawyers as well, partnership is the relationship which subsists between persons carrying on a business in common with a view of profit. Now, those few words mask a multitude of sins. Quite apart from the fact the definition is very old, it's still being worked out. A couple of things we can say as a preliminary matter. A business is a very, very wide concept. In particular, partnerships have become a very favored vehicle for venture capital investment. So a business will basically include not just a trading business, an active business. It will include investment business amounting in practice to little more than co-ownership. That's certainly the way things have evolved in practice here. So jumping on to Section 4 of the 1890 Act, Section 4.1 tells you that persons who have entered into a partnership with one another are called collectively a firm. Those of us who've been in firms of partnerships will know that instinctively. And we also know that a firm masks a multitude of sins. Section 4.2 is interesting and unusual because remember, from civil law perspective, the United Kingdom is not one jurisdiction, it's actually three: England and Wales, Scotland, and Northern Ireland. Now, the peculiarity of Scotland is that Scotland's legal system is largely based on French law pre-1707, pre the Act of Union, and that in turn is heavily influenced by Roman law. So Scotland approaches a number of issues from a rather distinctive perspective. Hence, in Scotland, unlike in any of the other constituent UK jurisdictions, a firm is a legal person distinct from the partners of whom it is composed. So I'll come back to what a partnership is in English law in a minute, but Scotland is unique. And that is relevant for the purposes of what we'll be talking about in a little while. The way a partnership works in Scotland is while the partnership is an entity, it's a legal person in its own right, the partners do not own its assets, the partners are necessarily the co-obligors. They're effectively the guarantors of its obligations. So let's move on a bit. So why are we even asking these questions? Well, looking at it from the domestic level, but there's a wider international level, our system, like so many systems, draws the distinction between the corporate tax system and the non-corporate tax system, as my King's students have heard me repeat ad nauseam for the last two terms. And the way the two tax bases are defined is very different. The way they operate is there's some commonality, but increasingly there has been divergence. And it is imperative to find out whether a legal person falls into the company bracket or the other bracket. Because if it's not in the company bracket, it cannot be subject to corporation tax, which is a distinctive tax. And so that takes us to Section 1121 of the Corporation Tax Act 2010. As it now is, it's been rewritten a number of times. And what that tells us is several things: that a company, for the purposes of our corporate income tax, is a body corporate or an unincorporated association, but crucially does not include a partnership. So we need to identify what a partnership is. Because if something is a partnership, ipso facto, it cannot be in this system. The members of it may be if they're companies, but the body itself, the entity itself, cannot be subjected to our corporate income tax. And the other point to mention, I suppose, is that corporation tax can be charged on non-UK entities. There are various grounds of nexus in relation to the UK to be subject to corporation tax, but the main ones are your entity is resident here, it's a company resident in the United Kingdom. If it's not resident here, it is carrying on trade here through a permanent establishment. There are other bases as well. In the interest of time, we will not go into them, but those are the two key ones. So you will encounter from time to time situations where a foreign body of some sort is carrying on what looks like a business through a PE in the UK. Is it or isn't it subject to corporation tax? Hence, we need to answer these questions. Hence, we need to go back to the makeup of Section 1121 and start dissecting what these various terms mean. Let's address very quickly the concept of an unincorporated association. It's a bit of a saga set out in excruciating detail in my thesis. I've distilled it here into two bullet points. The courts have basically concluded that an unincorporated association, it's not necessarily a legal person. cannot include an arrangement for a business purpose. So in principle, it can't include a partnership because a partnership is carried on with a view of profit and has a business. There is a standoff between the courts and the tax authorities about this. I largely side with the courts, although I can see why HMRC think the way they think. Let's just assume for present purposes that we can ignore unincorporated associations because that anything that's an unincorporated association can't be a partnership, and we're mainly focused on what partnerships are. Which brings us, I think, to the question that's going to preoccupy us most in the remaining time. What is the key difference between a body corporate and a partnership? Now, intuitively, you'd think you know the answer. You know, a body corporate is a major bank listed on London, BP, whereas a partnership, certainly in the high Victorian era, was a group of large gentlemen in top hats sitting in a cigar-filled room, drinking port and dividing up bags of guineas. Well, the world's moved on. Even for people like me who've been around a bit, I've never actually been a member of a partnership like that. So there was still one or two just about around when I started out, but I didn't have the good fortune or the ill fortune, depending on how you look at it, to be a member of one. And the main point, the main takeaway point, as we will see, is that because of the way business organizations have evolved commercially, it is increasingly hard to tell the difference between particularly a large partnership and a significant corporation. Take a major firm of accountants. It looks, walks and talks, if you ignore tax, very much like a large private company. And it was for this reason that when the Americans introduced their rules, the infamous or famous check the box rules, whichever way you care to look at them, in 1997, they effectively said, look, we can spend our lives drawing incredibly subtle and esoteric distinctions between entity A and entity B, but this is actually a waste of time and effort for an awful lot of people. What we need to do is define which entities are unequivocally going to stay in our corporate tax system and set them out. And then for all the other entities, we'll give you a choice. You can decide. Now, that's a gross oversimplification, as I'm sure Bernard will agree, of how the rules work, but there's an element of truth in that. Now, our rules do not work like that. We are effectively where the United States was pre-1997. So what we do is we look at the features, particularly of a foreign body, and try to analogize between it and our own domestic bodies and say, what does it look most like? Does it look most like a partnership? Does it look most like a company? Now, as we can see, this sort of this approach, often referred to as a corporate resemblance approach, is actually highly problematic and leads you down blind alleys on a regular basis. But let's try and look at a few factors which might help us to navigate a path through the minefield. Is there a point of differentiation over business purpose? Well, yes and no. Okay, a partnership has to have a business with a view of profit. Many companies, or what we would regard as companies, also have a business purpose. Although that's not axiomatic, some companies are charities. A partnership has to have, at least in English law, has to have at least two members. It is a business in common, so you cannot have a single partner partnership. That is possibly a point of differentiation, although it's not a particularly meaningful one. And the only sense in which it's relevant at all is that a UK private limited company can have a single member. When I started out, that wasn't true. You had to have a minimum of two members. Private limited company can now have a single member, whereas a partnership has to have at least two. But that doesn't strike me as a very secure basis for drawing such a fundamental distinction in tax terms between entity A and entity B. And obviously, a lot of corporate bodies have more than one member. Liability. Now, one tends to think of corporate bodies as entities where members have limited liability, and classically at least, partnerships as entities where members have unlimited liability. That was the first partnership I was ever a partner in 1997. In those days, I did indeed have unlimited liability, which made you stop and think. Well, sometimes. But the world, again, the world has moved on a lot. First of all, in the world of partnerships, we have seen the proliferation of limited liability partnership entities. Now, we just need to be a little bit clear what we're talking about here. In the United Kingdom, a limited liability partnership is actually a misnomer. It is a form of body corporate. It was created in that way, essentially to give them the strongest form of limited liability, but it is treated by fiction as a partnership for many, particularly direct tax purposes. So let's put that to one side. But if we look at, say, foreign bodies, if you walk around the streets of the City of London, there must be 20 to 30 American limited liability partnerships with substantial offices and substantial revenue streams operating here. And they are obviously not UK limited liability partnerships. They are created under the limited liability partnership statutes of various US states, most likely Delaware and New York. And it's very clear that under the law of Delaware and New York in particular, they are not incorporated entities. But nevertheless, to varying degrees, their partners have limited liability. I hope they do, because I was a member of one or two of them, although the limitation period may just about have run by now. So the point is that members of a body corporate will often have, classically have limited liability, but increasingly that is true of members of partnerships, even if you ignore the UK limited liability partnership. Now, we can debate precisely how far that limited liability goes, but for present purposes, let's assume in practice it goes a long way. There's been a tremendous degree of convergence. The other factor as well is that, at least in the UK, you can occasionally come across companies where the members have unlimited liability. But the important point there is limited liability is not really a very satisfactory way of distinguishing between what a company is and what a partnership is. One can focus on the transferability of interests in partnerships. This is something the Dutch have done historically. Again, if you look at our Partnership Act, an interest in a partnership is not freely transferable, but then nor are the shares in a private limited company. Obviously, it's different with a listed company. And it's also true that the so-called English classic limited partnership, not the limited liability partnership, confusingly, the one that was created back at the beginning of the 20th century, you can transfer interests in that relatively freely. So again, it's a very imperfect criterion for drawing a distinction. Now, as I said at the beginning, the classic Dickensian idea of a partnership is a relatively loose-knit affiliation of people who know each other very well and are in business together. You know, back in the days of Victorian gentlemen drinking port and smoking cigars and sharing guineas. Now, again, that would be contrasted classically with the tighter management of a company, the differentiation between a management layer and a member layer, all of which is good stuff. But again, the world has moved on. The way in which you can bet your bottom dollar that the way Deloitte is managed, there's no relation to the Dickensian paradigm, nor any of the major law firms. Centralized management is the name of the game, as much for partnerships as it is for companies. It may not be formalized in the sense that there is not a formal distinction between members and managers in the way that there is in a company, but the net result is pretty much identical. And if we're looking for determining factors, it seems to me at least we should be focusing on substance, not on labels. Another criterion, just to throw into the melting pot, legal personality, and this takes us back to Scottish partnerships. The English idea of a partnership, which is in fact an international outlier, is that a partnership has no legal personality. All an English law partnership is a form of contract where all the partners within certain parameters are agents of each other. There is the only sense in which an English partnership is a person is that there is a pot of so-called partnership property which is dealt with differently from the property of the individual partners. But there's no way does this amount to a legal person. Scottish firms, as I explained a few minutes ago, are very, very different, not least because of their historical origins. And the same is true, not just of entities formed in civil law jurisdictions such as France and Germany. But the Americans some years ago went very much in that direction too. American partnerships basically are legal persons. There are one or two peculiarities in Delaware, which I won't go into, but that's basically the default setting. I'm going to try and skip a little bit because I'm just conscious that time is rattling on. I have set out a little bit more detail on that slide about what the so-called legal personality of a Scottish partnership amounts to, because that's another important point when you're focusing on legal personality. There are different degrees of it. It's not an all or nothing. For example, the nature of the legal personality of a Scottish partnership is significantly more qualified than that of a fully incorporated body in the UK, which is another reason why overemphasis on legal personality as a deciding factor between what is and isn't a partnership is as likely to mislead as to illuminate. And to some extent, outside the tax sphere, the UK courts have been prepared to recognise this. I refer in the third bullet on that slide to two cases, one of which is pretty elderly actually now. It was decided on the eve of the First World War, where English courts were prepared to recognise that a foreign body coming from a different legal system was nevertheless behaving in a way which was analogous to an English partnership, and therefore it should be treated as such, notwithstanding that as a formal matter, it did not necessarily have the features that one would expect if you were dealing with an English partnership. And if I just move to the last bullet on this particular slide, back in the 1920s, one of the very few decided cases in this area was a case called Dreyfus, which had nothing to do with Jewish army officers being packed off to Devil's Island. It was actually involved a company which still exists, actually a major grain merchant in France, which had a very successful practice in London, which the then Inland Revenue decided it was going to tax. And basically, it was two brothers operating through a French vehicle called an SNC. And the SNC had a London office, and the brothers said, the SNC is a company, therefore you can't tax us, the brothers, to the higher rates of income tax. And the brothers won in the case. But subsequently, it is the UK tax authorities have basically concluded that that case is misleading. The expert evidence was flawed. And again, it was another example, a bit like a Scottish partnership. And remember, Scottish partnerships are inspired in large part by French law, of a foreign entity with a legal personality, but disregarding the legal personality, the entity was behaving in a way which was very different from the way in which the corporate works. And in particular, the members under French law were entitled to the underlying profits of the entity as they arose, which is classically never the case in relation to a company where the profits belong to the company and members get, if they get at all, a share of profits as and when they receive a dividend. Couple more factors which have been thrown into the debate from time to time as key differentiators, the so-called perpetual succession factor. What does that mean? It means that you ask the question, can an entity remain in existence? In other words, does it have to be dissolved if a member departs or becomes bankrupt? And if it does have to be dissolved if a member departs or becomes bankrupt, then it cannot be a corporate. That's the classical thinking. However, again, it's a criterion which is apt to mislead, because a lot of the foreign bodies I've referred to, and SNC being a good example, do not operate on the basis that if a member departs or becomes bankrupt, they are automatically dissolved. So it may make sense in relation to an English partnership, but when you've got a foreign body which is behaving in a very similar way, putting it into the corporate bucket just on the basis of that is fraught with risk. And furthermore, it also makes little commercial sense in the modern world. Most modern partnerships in this country are now limited liability partnerships under the UK statute. I explained that's a form of body corporate with special tax treatment. But we do still have some very prestigious old-fashioned partnerships. And exhibit number one is none other than Slaughter and May, arguably the most famous law firm in this country, which remains a general partnership. Not least, I suspect, because they then don't have to publish accounts. But Slaughter and May, for whatever reason, is a general partnership. Now, it seems to me pretty clear that when people retire from Slaughter and May, I don't think Slaughter and May partners go bankrupt, but if they retire from Slaughter and May, then there is no question of Slaughter and May de facto dissolving and reforming. There is a mechanism within the partnership agreement whereby Slaughter and May sails on majestically into the future, as one would expect, and the American partnerships have achieved something similar. So perpetual succession, it's an interesting idea. One understands what people are driving at, but A, it's extremely esoteric. And it's also a factor which in the real world has little or no impact. And I suppose what this brings me to is the last point at the end. There is a danger in over-focusing on one differentiating factor, especially a very technical one, given we are dealing with bodies coming from a diversity of legal traditions, the civil law tradition, the American tradition, the common law tradition. And in fact, when the Americans use their old rules, and indeed under the current German rules, the approach is one of not requiring you to pin everything on one factor. As long as you can produce a number of factors pointing you in one direction rather than another direction, that suffices. But I still need to sort of try and come to an answer on this. The answer I have come to, for what it's worth, is that in the modern world, if and insofar as there is a factor which makes the difference, it's the factor I've highlighted in bold at the top of the page. Is the entitlement of the members to entity profits as they arise the key factor? I would argue it's certainly a very strong pointer that what you're dealing with is something which is not a corporate body. And you need to stop and think very hard in that situation as to whether there are any good reasons for not treating that entity as a partnership. This is to some extent based on a case which reached the Supreme Court 7 years ago, the Anson case, in relation to a Delaware LLC. Now, Anson is a long saga. I won't go into it in any detail. The headline's conclusion is it did not definitively decide that a Delaware limited liability company was a partnership. It simply regarded it as transparent for UK foreign tax credit purposes. However, the basis on which it reached that conclusion was on the set of findings of fact in the first tier tribunal, where my PhD supervisor, John Avery Jones, was a judge. And as the third bullet summarizes, John basically concluded that the LLC lay somewhere in between a UK company in the fullest sense of the word and a Scottish partnership. I'll leave you to read the rest of the bullet. And the Supreme Court put quite a lot of weight on that. What it also concluded was the fact that the LLC was an entity in its own right was not a problem. It could still be transparent. There was an entitlement to profits as they arose, because profits are not a property law concept, but an accounting concept. And under the relevant governing law, that was the nature of a member's interest. Again, in the interest of time, I will not digress into why HMRC think Anson is wrong, but that is where the most senior court in the country last left the question. But I think it gives us a very useful indicator if the governing law of the relevant entity indicates that members are entitled to underlying profits of the business as they arise. And I don't mean a situation where the business earns profits and then automatically decides to pay a dividend. That isn't enough. It's got to be a situation where the governing law actually provides that the profits are the members' profits, distributed or undistributed, not the entity's profits. And as I say, I think that's probably the least worst defining criterion for a partnership at present. But I go on to sort of highlight a number of deficiencies with my own argument. It does still leave us with some very fine distinctions. In particular, what's the difference in that case between a partnership interest and a profit-related loan? Well, if you look at a limited partnership, it's probably a distinction which is more honoured in the breach than in the observance. The approach also of defining partnerships and companies by focusing on a criterion like that is that it makes for a very unwieldy and costly process, because you're going to need to spend time and money getting expert evidence from the relevant foreign jurisdiction and getting the tax authorities to agree with it. The saga of Anson itself shows that that is far from a straightforward process. And again, is another reason why the Americans decided to drop all this and go for a much more binary approach, saying either something's on our list of corporates or you get a choice. The UK has set itself as a policy matter against that approach for reasons which I think are a bit misguided. I don't think we actually need to go the whole hog in adopting the American approach, but the underlying philosophy of it on which it's based has quite a lot of merit. I suppose what I'm going to do is, before I flick to the last slide and then we go to some questions, is deal with one point which has floated around in the tax press here, which is the idea that you can somehow take a foreign corporate body and in an entity which is clearly created under the incorporation statute of jurisdiction X, fiddle around with its articles of association or constitution, whatever it is, and turn it into a transparent entity for UK tax purposes just by manipulation of the members' rights. Now, I'm skeptical about this. I've seen the idea floated more than once, but I think while the entitlement to profits criterion as they arise is a very important one, I do really doubt whether a UK court is going to allow taxpayers just to do DIY transparency by fiddling around with the company law of various foreign entities. In particular, if they are presented with an entity which has clearly been formed under the regular incorporation statutes of whatever jurisdiction it is going to be, then I strongly suspect that they will push back pretty hard if people try to argue that that is in some sense a flow-through entity on the basis of adaptation of its constitution. And I think this goes back to the point I made a minute ago, that while one reading of the Anson case gives some support to that, the important thing to bear in mind is that when the court decided that the LLC was flow-through, it was consciously resting that conclusion on the fact that John Avery Jones had told them there are some pretty strong similarities between this entity and a Scottish partnership. Now, that will not be true if you take a Delaware corporation and just fiddle around with the members' rights. You will not be able to say that. And I think therefore, and the reason why, and the policy reason why a UK court, I think, will balk at that, is that if it goes down that avenue, in essence, the corporation tax base of the country is up for grabs. And as we've seen in the last 18 months, whereas for 10 years we had been gradually reducing our corporation tax rate, the government is now looking to corporation tax to actually raise significant amounts of revenue. So I don't think that that argument is likely in practice to develop much traction. Oh, sorry, going the wrong way. Just leave you with a few points, which are really debating points. There's no right answer. Speaking for myself, I actually think that as a policy matter, the United Kingdom should treat more so-called partnerships as companies for corporation tax and other purposes, and other tax purposes at least. However, I recognize that this is a very marked retreat from the trends of the last 20 years, because especially when we created the limited liability partnership body back in 2000, what in essence we created was, on an entirely bespoke basis, a company with flow-through characteristics. But again, going back to the point I made a minute ago, corporation tax now seems to be back in favor as a revenue raiser. And with that in mind, and also with commercial reality in mind, it seems that we should start, the test that we should be applying to some partnerships at least is, if it walks like a duck and quacks like a duck, then it must be a duck. And we should recognize that. And that would also be more consistent with the spirit of our corporation tax rules as originally conceived 2 years after I was born. A different world, but the clear divide between the corporate system and the income tax system would be better preserved. Now, I don't know if I overstayed my time. As I say, I'm deliberately going to steer clear of the treaty stuff. Does anyone have any questions?
One on the chat. This is going back from the audience. One of the people in the audience asked if consortia are subject to corporation tax.
Depends what you, the short answer is, what we define as a consortium is essentially a joint venture company. At least if that joint venture company is UK resident or has a UK presence, then yes. It doesn't actually need to be resident in the UK. There's more to that debate, as my King's students know. But basically, the short answer is yes. Of course, you can use the term in a looser commercial sense to cover a broader spectrum of joint ventures, and some form of co-ownership or partnership arrangement could equally be classified, at least commercially, as a consortium, although not in the narrow tax sense. And that obviously will not be a taxable entity in its own right. Okay.
Michael, a question.
Yeah, absolutely.
Do you see other countries going in the same direction as the US? The UK is clearly doing the same thing. But what about other countries? I know you've looked at Germany and France and the
Netherlands, yeah, okay. The UK's policy at the moment is one of masterly inactivity, which sometimes has a lot to commend it. But anyway, we'll park that. The Germans have produced rules in the last year, which in certain situations enable a partnership to elect into corporate taxation. But as I understand it, it's a one-way street, and it's an anti-avoidance street. What you can't do is go the other way. So you can't say, as you can with a US LLC in certain situations, elect for flow-through treatment. It's a one-way street. The Dutch I need to catch up on for a number of reasons, but where the Dutch were at until there was a hiatus in the debate was that in certain situations, they were going to make their classification of an entity align with the relevant foreign entity. Now, this is an idea which has been floated by a number of jurisdictions. South Africa is another. And it raises as many questions as it resolves, and we don't have time to go into it. But within certain parameters, the Dutch were going to go down that route. And the other thing the Dutch were going to do was, the Dutch have a rule, I half alluded to it earlier, that a Dutch partnership is taxed as a corporation if the members' interests are freely transferable. And that has been a very fertile source of tax planning for many a year. The Dutch were going to jettison that rule. They were going to, in essence, provide that a Dutch CV, a Dutch limited partnership, would always be flow through for Dutch purposes. So what you couldn't do was create a hybrid, where it's flow through for non-Dutch tax purposes, and by fiddling around with the transferability of members' interests, you turned it into corporate. That, as my recollection, is what the key features of the Dutch reform is. It was supposed to come into force beginning of 2021, but it didn't. And I think elements of it are still being rethought. And as I say, apologies, but I'm a little bit behind the curve in terms of where things are at. And did you mention one other jurisdiction? You mentioned France. Yeah. All I know about France has this, let me spend a minute on it. France has this very distinctive idea that a partnership is itself a taxable body. Now, it's a curious idea to grasp, because French partnerships do not get assessed tax in the way that a company does. The tax is levied at the level of the members by reference to the members' own profit shares and tax characteristics. Are they individuals? Do they have reliefs? Do they have losses? Whatever. Now, in all other countries, that would be regarded as a form of transparency. It is here, it is in Luxembourg. The French do not regard that as transparency. They, in essence, regard the partnership as having its own liability, but the liability is effectively collected from the members. And the French thought about 10 years ago that they would reform that. They actually produced a reform bill, but then they decided not to reform it. So as I understand it, the French rules in this area remain as is. The only knock-on effect of that is the knock-on effect I alluded to at the beginning, that France has a very specific treaty policy in relation to how it deals with partnerships. And the UK-France treaty is a very good example of how France has spelt out what it wants in terms of a treaty with one of its major trading partners. And interestingly, when the multilateral instrument was signed, when BEPS was embodied in the MLI, the UK-France application of the MLI does not change that. It changes other elements of the UK-US treaty, but the special rules on entity classification and hybrids remain as is in that treaty, notwithstanding the MLI. Have I left any other jurisdiction?
No, I think so. It's interesting with France, the way it's treated, the Japan-France treaty and the Japanese TK.
Yes.
In the same way as they have in the UK.
Yes, yes.
So it does go across different borders.
Yeah, and
actually it's quite fundamentally logical.
Yes.
The French do it.
Yes.
One doesn't often call French logical.
Well, they pride themselves on their Cartesian logic, but oddly enough, and again, this is something my thesis went into in a lot more detail because I got quite interested in the area, and as Joy knows because she read the damn thing. The French do, in very limited situations, have a pure transparency concept, but it doesn't apply to most partnerships. So there are one or two French entities which they treat as transparent in the way we treat entities as transparent, but they're as rare as hen's teeth. And by and large, this idea of translucidité, the translucency, is their governing approach to partnerships and is manifested in their treaties.
And I suppose one of the interesting things with the UK is at least they published a list of what they think most overseas entities and partnerships are for UK purposes. I haven't seen that for many years, but I presume it still exists.
Our list?
Yes.
Yes, our list does exist. Actually, let's just spend a minute on that. Yeah. The UK has a list, it's a bit like the Mikado. And on the little list is, well, it's not a little list now, it's quite a long list, of various entities which HMRC have looked at over the years, not so much to decide whether they are partnerships or companies, but to decide whether they are transparent. Because remember, there are entities other than partnerships, notably some trusts, which can be transparent. The weakness with that list is that you don't know the factual basis on which they reach the conclusion. It's probably quite a good practical guide, but interestingly, the Dutch have a list. And the Dutch list is much more helpful because the Dutch list doesn't just give the entity and the conclusion, it gives at least a potted summary of why they got to the answer. So it seems to me if there were a simple basic tidying up exercise that were to be done with our list, it would actually help to give us some backup reasoning in relation to some of those entities, because various unusual entities have been creeping onto that list in recent years. The Channel Islands in particular, both Guernsey and Jersey have come up with a body which purports to be a limited partnership, but also purports to be incorporated. Now, to me at least, this is sort of Alice in Wonderland. This is imagining 20 impossible things by breakfast time. But they claim that you can have such a beast. And HMRC has looked at it and concluded, for reasons I kind of understand, that it is actually in essence a flow through. It's transparent. but it would actually be helpful if they actually gave the wider world the benefit of their ruminations, rather than just giving us the bald label, date, entity considered, result. Because the Dutch have definitely gone the extra mile. How are we doing? How are we on our time?
Yes. Can I just make one observation, Michael?
Absolutely.
One of the things I always say to my students is to hear you talk about partnerships in the way you do is absolutely a demonstration of critical thinking, which is what we all want in dissertations and theses alike. So thank you very much for that.
My pleasure. I have been around this circuit a few times, so it's, if I hadn't got better, there'd be something wrong.
There is one comment from the online audience that is interesting and that you may wish to comment on. I don't know.
Yeah.
So Luis Castillo says, in Portugal, even though we have partnerships, we don't apply tax transparency. I'm paraphrasing slightly, based on the nature of the entity, but rather on the nature of the activity that it renders.
Right.
If the activity is commercial, it's opaque. If it's a so-called liberal professional like lawyers, then it would be transparent.
Right.
The idea here being that liberal professionals should be taxed the same way, regardless of whether they use an entity or not.
Yes.
That's his explanation of the rationale.
Yes.
And he asks does this solution make more sense for this approach?
Well, I suppose this is probably just coming at it parochially from an Anglo-Saxon perspective, so I get my defense in early. I guess the way I would have approached it is that the transparency or non-transparency of an entity should not hinge on the activity it carries out, but more how it carries out that activity. So whether it's selling motor cars or manufacturing widgets or being a lawyer or being an accountant, that will be my sort of instinctive reaction. Now, clearly there are other schools of thought. You've just articulated one. I suppose the other point, which this bears out, is that there's still, because of the discontinuity between systems and traditions, there's still an enormous amount of scope for hybrid situations to arise inadvertently as well as deliberately. We tend to think, for all sorts of good reasons, that hybrid mismatches arise because wicked people get together to confect tax avoidance. Now, there's been plenty of that. Let's not go to, let's not beat about the bush. But there are also many situations where hybridity arises just because we live in a diverse world. And Bernard's just given us an example of that.
Well, Mr. Castillo is giving me really, I've just had the pleasure of reading it.
You were the trusty messenger, for which many thanks.
Not at all. And thanks also to Yazin Genova, who's the one who posed the original husband.
Yes, thank you. How are we doing?
Do you have any free chat? Have we covered all the questions?
Yes, so far.
If you don't have any more questions, I'd like to thank you, Michael, for this really presentation. As Joy said, it just shows so much critical thinking, identifying the issues, and thank you for making it so easy for us to understand some very complex concepts. So thank you very much.
It's a pleasure. It is the tip of a very large iceberg. Perhaps you should leave it at that.
Thank you, Michael.
Thank you very much.